Of course, this is just the landing page, and then go to the next slide.
Reports were tested with the antigen testing, the rapid antigen testing, and the positives were confirmed with the PCR test.
Next slide, please, Jackie. Okay. Honorable Chair, I will not spend time on this legislative mandate. We've already presented to Scopa, and Scopa is familiar with the SIU legislative mandate. Of course, if there are any questions of clarity, I will take that. Suffice it to say, at this stage, as we open up the presentation, Honorable Chair, that in the SIU mandate, legislative mandate, we have a provision in the legislation that says once the SIU has completed the investigation, it then hands over the report to the President. And then it is the President's prerogative on how to deal with the report. Now, with specific reference to this report, which we've been handing over to the President on a 6-weekly basis, this report deals only with the matters that have been finalized and outcomes have been reached. For matters that are still ongoing and they're included in the third 6-weekly report to the President, have not been covered in this report. And I need to just put it on record, Honorable Chair and Honorable members, that by direction from the President, communicated to me in a letter dated 14th January 2021, the SIU was given the authority to make public sections of the third interim report that deals with finalized investigations. This is what was conveyed to us from the President's office, as the President having agreed that SIU can make the report public. And that saw us as SIU then releasing the report on the 5th of February 2021. Okay, the next slide. Next slide deals with vision, mission, and values. Honorable Chair, once more, we have presented before Scopa on the SIU vision, mission, and values. If there are any questions on that, we can take them on. Next slide. Right. These are the consequences. Again, we've presented to Scopa before in terms of what the SIU investigation seeks to achieve at any point when we conduct our investigations. Just to reiterate that we seek to achieve the outcomes relating to civil litigation and recover the funds in terms of the irregularities committed, where the officials, there's evidence pointing to their guilt in terms of the misconduct. We then refer the evidence to combating the virus, accounting authorities or accounting officers.
The public interest, it's a national.
Then we also refer to NPA, that evidence that points to the commission of an offense, and then referral to other regulatory
we want to play our role in helping.
We are going to be referring to all of these outcomes during
organized labor, working in partnership with organized labor and government, to be able to roll out the vaccine. So we have agreement. And
the next slide, Honorable Chair and Honorable members, deals also with the strategic focus that has sought to enhance the way of business in SIU.
From the very significant medical capability in the sector, obviously
I will not go
based on our experiences of the TB pandemic, and basically given the significant focus on health and safety in the sector,
and I think
we believe that we can
really turning the tide on that.
60 to 80,000 people per day. Those are the preliminary numbers that we've got back from most of our members in terms of what their capability is. And so we think that it's possible for the sector to help vaccinate a workforce, the full workforce, and as much as 2.5 million community members, because it's very important that communities within the mining areas are also vaccinated to create
those areas
the country level immunity that we require. And so we've been working very hard on taking that
most
commitment
of the
through.
spending is
Given the
done
fact that the government is the sole procurer of the vaccines, we have been involved in a discussion as a whole, not just the mining sector, also contributing to the vaccine acquisition component. The National Treasury have indicated that given that this is a public good, that the vaccines will be procured by government through Treasury. They've made the funding available.
Of COVID-19,
but that doesn't mean that we can't, on a tumor basis, have individual companies contributing to the solidarity fund, which may help, as we go forward, if there are any gaps or shortfalls. But a lot of our commitment, we estimate that vaccinating, 2 to 3 million people in communities and in the industry would be probably about a 300 to 400 million rand contribution just in terms of the logistics and getting this done, excluding the cost of the vaccines. So just illustrating our significant commitment to this issue. We have been engaging with government through the DMRE, into the Department of Health and others on the concept of the vaccination sites being listed as points of care. A point of care is basically you can then facilitate the actual vaccination process taking place. We have also been requesting that mine workers, smelters, refineries, and the mine rescue services also should be listed as essential workers. We can't have too many gaps in the whole process. It's quite important to ensure that
the expenditure patterns,
all mine workers, given the settings that we work within, are vaccinated as quickly as possible, and we are committed to playing that particular role. So there is currently registration underway of 1.5 million health workers. That's phase one. Mine workers are in the phase 2 process as essential workers, together with vulnerable groups and populations in congruent settings. And again, we've had a series of already 2 meetings this year with the trade unions, several meetings with the DMRE, and obviously we are working through Business for South Africa, which is a subset of Business Unity South Africa, to make sure that we have that sort of impact on logistics, giving ideas and making sure that our facilities are registered for the vaccine rollout, etc. And obviously when the vaccines are available, we'll certainly play our role. We reckon that we can do approximately 2.5 to 3 million people.
Honorable Chair and honorable members, as we investigate, there are some limitations that we have come across. Of course, most of the limitations, we don't just experience them, but we put in place measures to circumvent them or improve on them. But we thought it appropriate that we document those limitations. And that can be found on page 11. Page 11 of the actual report. The next slide. Now, these limitations are as follows. As the investigating teams went about their investigations, we found that very limited original documentations were kept by the state institutions relating to the appointment of service providers for the procurement of PPE. Physical searches for documents were conducted to try and find the documents. The SIU managed to obtain some electronic documents and also obtain some documents from the service providers in order to recreate paper trails. This really just goes to indicate, Honorable Chair and honorable members, that document storage or document filing in the department or some of the state institutions presents a problem. Destruction of evidence, documentation, hardware devices such as computers and mobile phones. In this regard, of course, we have a method in which we are able to find, particularly on the electronic transactions or communications. We've got a method where we go to the servers, and our team in SIU have got the tools to ensure that we can trace those documents through the servers. Some of the officials of the state institutions worked on a rotational basis. This is probably particularly because of COVID-19 period. So there were delays in collecting the required documents. Some state institutions also had to close their offices because of COVID-19 infections. Unavailability of officials who had to sign off affidavits that have been provided. Unavailability of officials who had to quarantine or were working from home and did not want to have face-to-face interviews. In this regard, as we went on, we then devised the electronic means of online interaction with the witnesses, and we found that it works. Where there's a requirement to sign off on an affidavit or any statement, then arrangements are made subsequent to the interaction. There was no cooperation from many of the officials, particularly the officials in the supply chain management and the finance departments. This was largely because of their involvement in the irregular procurement process. Of course, in this regard, where there is non-cooperation voluntarily, then we would invoke the SIU powers in terms of the legislation that enables us to investigate, and we would then proceed with the investigation on that basis. Local politicians' involvement in the administration of municipalities, that was observed. Unavailability of witnesses because of COVID-19, specifically staff that had to be interviewed at the hospitals. Witnesses also had to quarantine. As I indicated there, we ultimately improvised and made the opportunity for online interaction and physical interaction only when there's supposed to be signing of documentation. The fear of witnesses for victimization and or feeling unsafe and hesitant to be interviewed to provide statements or evidence. Of course, in this regard, we also ensure that where we become aware of it as SIU and indicated by the witnesses, we then ensure that we have the witness protection program that is available so that the witnesses can be protected in the process. Unavailability of staff in the banking industry. Most banks operated with skeleton staff because of COVID-19, which delayed the release of bank records, and that had been requested. Delays with receiving information from SABRIC, the Fusion Hub, and the FIC. This point we've discussed. Yesterday we had our ACTT, and in that we already have attended to this matter. FIC themselves, where the Fusion Hub is really located, have already done corrective measures to ensure that delays are not experienced, particularly with the assistance for the request of bank statements. Non-availability of officials to receive and acknowledge our disciplinary referrals because no face-to-face meetings were allowed at some of the state institutions. In that regard, we would then also resort to sending the statements electronically or the referrals electronically, and ultimately requesting acknowledgement of receipt and following up. SIU members were threatened and were intimidated by both officials and service providers. We do ensure that where we become aware of that, protective measures are put in place for SIU members to proceed with their investigations without fear, favor, or prejudice. The geographical location of state institutions and having to travel extensive distances, those were some of the observations and limitations that we experienced. Despite all of these limitations, Chair, as I said, we didn't just experience them and not put any mitigation plans. We mitigated them, and that is why we were able to reach this stage where we produced the investigations and the quality of investigations as we did. I'll go to the next slide, please. During the investigation, Honorable Chair and Honorable Members, the investigations revealed certain observations, which we have also documented. And these observations, in many instances, form the underlying observations that we take into account when we reach our findings. These observations, Honorable Chair and Honorable Members, can be found on page 12 to page 14 of the report. I start with the observations. Next slide. It appears that the evidence revealed that persons in positions of authority within provincial government believed that the declaration of a national state of disaster meant that all procurement is automatically now conducted on an emergency basis and without compliance with any of the normal prescripts relating to public sector procurement. But they didn't realize that even emergency procurement must still be conducted in accordance with certain minimum prescripts to ensure that, as far as possible, that processes remain fair, equitable and transparent, competitive and cost-effective, as prescribed overall by Section 217 and by the PFMA of 217 of the Constitution. We just make an example there that they needed, amongst others, to motivate to the accounting officer, accounting authority of the state institution concerned, why is it wholly or partially impractical to invite competitive bids and have the accounting officer or accounting authority record the reason for such impracticality and approve then a SCM deviation in terms of Regulation 16A64 of the Treasury Regulations, which must then be reported to the relevant Treasury and AGSA. So these are some of the processes that they should have followed on, but in many instances they have not. Further observation is that various officials of provincial government merely rubber-stamped the decisions taken by and or accepted and gave effect to unlawful instructions from officials more senior than them, which resulted in a complete breakdown of checks and balances protection normally afforded, amongst others, as an example, by the principle of segregation of duties. We found that in many instances, only one individual would deal with the process end to end, where there would then be no segregation of duties. As we state there, that as an example, the capture of the transaction, the second person would approve, and the third person would probably authorize. So those are the checks and balances that the segregation of duties that we had expected and are in place, but in many instances they were compromised. Consequently, officials working with support services processed commitment letters, purchase orders, invoices, and payments without ensuring compliance with SCM prescripts and other control measures. Next slide. Furthermore, it appeared, as evidence revealed, that certain influential people within provincial government, they really do not trust procurement processes undertaken by the national government. For example, the procurement process undertaken by National Treasury to secure transversal contracts that where everyone in government would participate. And these officials, they hold, which in our view is a false view. They hold an incorrect and unwarranted view that such procurement processes and resulting contracts create monopolies in public sector procurement, which excludes fair opportunity for local, provincial, black empowerment or SMEs, suppliers or service providers to compete fairly for such contracts. This perception seemingly resulted in the provincial government intentionally avoiding the use of transversal contracts as inter alia prescribed by Practice Note 8 of 2019-2020 and ignoring the prescripts of Practice Note 3 of 2020 and 2021, which required from all state institutions to centralize all their procurement within the National Treasury team. And the observation, that team comprised of the National Department of Health and the Chief Procurement Officer at National Treasury. It was assisted by Business South Africa on a non-profit basis. All of this A and B, ignorance and avoiding the use of transversal contract resulted in the procurement irregularities and gave loss and prejudice to the provincial government and the fiscus. Now, if you bear in mind, this is another observation, that the national state of disaster was declared on the 15th of March 2020, where after the PPE procurement commenced in earnest, certain service providers were found to have been registered on the CIPC during February and March. And in our view, thus would not or could not have had demonstrable track record for them to warrant being appointed to deliver on the COVID-19 service. Companies awarded contracts were not registered on Central Supplier Database. The next slide. Central service providers, certain service providers were already in the deregistration process when they quoted and were awarded contracts. Their tax status had to be verified with SARS, as this would have impacted on their registration on the CST. The type of goods supplied were not consistent with the nature of the business registered on CIPC. As an example, that is, they should not have been requested to quote for the services. Product specifications were ignored, and products that were not suitable for their intended purposes were purchased, and in several instances against the advice of expert opinion on the usefulness of the product. Certain companies were awarded BBBE points as level 1 contributors when they in fact did not qualify. Political pressure in other instances that we have observed played pressure they played a role in the procurement of the PPE. It appears that the names of the service providers were determined before the SCM process commenced. The delivery of substandard and or PPE that does not comply with the technical specifications contained in the invitation to submit quotations. Furthermore, certain PPE were not packed according to predetermined standards. There was no attempt, Honorable Chair and members, to negotiate with suppliers in bringing prices within the threshold suggested by the Treasury, and this in other instances resulted to overpayment for goods. We observed that the departments lack basic control measures that will establish, whether a correct product delivery happened. In several instances, we found under delivery of items, which was really worrying. There appears to be no verification protocols on supplier registration details. This has resulted in several suppliers claiming VAT when they were not registered with SARS as VAT vendors. And in this regard, Chair and honorable members, we would then interact with the South African Revenue Service to ensure that this is attended to. We also observed that suppliers were using front companies to obtain multiple contracts from the departments. We observed cover quoting by officials and suppliers, splitting of bids to meet the quotation and or delegation threshold, misrepresentation from suppliers by not disclosing their close friendships with officials who were involved in awarding PPE contracts. The PPE was packaged under a false or forged or cloned label. Those were the observations thus far. I'll move over now to the contracts under investigation. We've included a paragraph later on, and the committee will see. As it will be seen on that paragraph, allegations were received from various sources, including state institutions. The allegations were then registered and assessed against the investigative scope and period of the proclamation. If the allegations were found to fall within the investigative scope and period of the proclamation, these matters were then referred to the relevant SIU investigation team in the provinces or national. Matters were prioritized based on the potential outcomes to be realized in the shortest amount of time based on the available resources. And we are of the view that that really has worked out well. This can be found on page 9 of the actual report. The next slide. On this slide, which is in page 10 of the report, this really shows that the number of allegations that we have received, they count cumulatively up to 189, Honorable Chair. You'll see starting on the bottom graph, in the national, we received 51, Gauteng 34, KZN 26, Eastern Cape 17, Mpumalanga 16, Northwest 12, Limpopo 12, Free State 11, Western Cape 9, Northern Cape 1. This was as at the 25th of November of last year. And we need to indicate that the new allegations keep on coming in. So the next interim report, due to the president, will probably show an increase in allegations. Next. Oh, thank you. The slide that's in front of the committee now can be found in page 18 of the report. That slide, yes, repeats that we got 189 allegations. We obtained documents in respect of approved allegations, and from that documentation, as at the 25th of November last year, 2,556 contracts awarded for COVID-19 related services were identified for investigation. These contracts were awarded to 1,774 service providers. By value, 26% of these contracts have currently been finalized. If you look at the graph, finalized, we finalized number of service providers, 141, number of contracts finalized, 164, valued at 3.5 billion, and that translates to 26%. Ongoing, relating to 777 service providers, number of contracts, 1,541 to the value of 6.8 billion. That translates to 51%. Investigations still to commence. And as of yesterday's, there's a different picture, which we will obviously report in the next report, that the investigation had actually commenced. But as at the time of the report, 856 service providers covered by 851 contracts to the value of 2.9 billion, translating to 22%, still had to commence. The total, as we indicated, above 2,556 contracts valued at 13.3 billion. Next slide. Honorable Chair and honorable members, this is where now we deal with the outcomes of the investigations, as I indicated above, that in areas where we have found irregularities, we then reach certain outcomes. We deal now with the civil litigation matters. These matters are covered on page 19 to page 30 of the actual report. In the Eastern Cape, Department of Health, it's the SIU versus FAPCOM. This matter received quite a publicity. The course of action is based on the irregular procurement by the Eastern Cape Department of Health of motorcycles with a sidecar to transport patients, which resulted in a process that was not fair, competitive, or cost-effective. The matter was heard in the Special Tribunal in the Eastern Cape, and the Eastern Cape Department was interdicted from making any further payments to the supplier and from accepting delivery of any goods from the supplier, pending the finalization of the review proceedings, which will be in the Special Tribunal. They are coming in the Special Tribunal on the 22nd of April, 2021. Still in the Eastern Cape, in the OR Tambo municipality, this was what was referred to as the door-to-door. This was the awareness campaign that was done by the municipality. I should have indicated the above matter of FAPCOM is valued at more than 10 million. And the next one of door-to-door is valued as more than 4.8 million. It was instituted on the 26th of October 2020. This matter relates to an investigation into the irregular procurement of the awareness campaign that was conducted in the Eastern Cape. Civil proceedings have been instituted by SIU against an entity called Partilizwi Training in the Special Tribunal to review and set aside the award and the resultant contract. The matter is not being opposed and will be set down. As at the time of the report, we did not have the date of the tribunal, but I've asked our litigation team to follow up on that. It's still in the Eastern Cape is the Aliani trading matter, valued at more than 2 million, instituted on the 30th of October of 2020. This matter relates to the procurement of PPE for the Department of Education in the Eastern Cape. The SIU successfully applied to the Special Tribunal to have the bank accounts of the first 4 respondents frozen and to interdict the department from making any further payments to them. The SIU will issue summons to recover losses suffered by the department. Next slide. In the Gauteng province, again, this matter also received quite a media coverage, is the SIU versus Ledla structural development. In this matter, a contract to deliver PPE was irregularly awarded by the Gauteng Department of Health, while unit prices were also artificially inflated by between 211% and 542%. Notwithstanding the fact that the department was aware that the SIU was investigating the contract and the department had stopped almost all payments in respect of the suppliers under investigation by the SIU, on the 3rd of August, the department made payment to the value of 38,758,155 to the supplier. That was really, we were caught by surprise on that. This had immediate clearance and substantial amounts were moved from bank accounts of supplier to the bank accounts of 2 other entities who in turn transferred and paid the funds to at least 36 other entities. On or about the 6th of August, at the request of SIU, the FIC implemented a directive to freeze a total of more than 26 million in the bank accounts of 39 entities. So we did so simply because we had observed that if we do not, the money had the potential that it would disappear. The proceedings were then instituted in the Special Tribunal under case number GP 7/2020, and it was enrolled on the 20th of August 2020. On that 20 August 2020, the matter appeared in the Special Tribunal and the following orders were granted. The first to the 39 respondents were prohibited from dealing with the funds. So this is what we call that the amounts to the value of more than 26 million were frozen in their accounts. And this is where FIC really assisted. At the time we went to the Special Tribunal, so those matters were still frozen by directive of FIC, and then we could then obtain the Special Tribunal order to get them freezed. The implementation of the contracts between the department and the first respondent, which was the later structural, was suspended. And the first to the 42nd respondents were interdicted from giving effect. So effectively, the contract could not be executed. And there were government employee pension fund and the GPAA, which were the 43rd and the 44th respondents. We did so simply because there were other officials which we had to freeze their pensions. And that's why we included these pension companies or organizations as respondents. And as a result, they were interdicted from releasing the pension benefits of the former chief finance officer of the department pending the outcome of the damages claim, which is instituted. The department was also interdicted from making any further payments to Ledla. The return date for all of this was the 6th of October, 2020, and a case management meeting was done. The case was then opposed by all these respondents. The Special Tribunal then postponed the matter to the 21st of November. An interim order was extended. Prior to the hearing, SIU then withdrew matters against the 26th responded after it agreed to refund 2 million to the department for that amount to be attached, and then that was then released. The 35th respondent, because it had never received any payments from leisure, the matter was then withdrawn against them. And on the 20th of November, wherein judgment was reserved. Judgment was handed down on the 10th of December, Honorable Chair and members. The order handed on the 10th of December was as follows. The court reviewed and set aside the contract that was concluded between the department and leisure. Right? And then the court extended its interim order made in terms of the pension fund of the CFO. The court confirmed the interim orders that were granted against the leisure and the other respondents. And on that day, a total amount of 16.6 million was forfeited to the state. So that decision gave finality. But on the next slide, 29, yes, thank you. The court, the special tribunal discharged the interim order to other respondents, and the basis of discharging the orders was that those respondents could then account on the monies that were found in their accounts to the satisfaction of the special tribunal. On that day, then the special tribunal ordered SIU to obtain an independent audit report in respect of the remaining respondents so that the court can make an appropriate ruling. The matter was again postponed and it was heard on the 4th of February, last week, Thursday. Next slide. Next slide, yes. On the 4th of February 2021, the special tribunal then further declared an amount of approximately 7.4 million to the state, which was frozen in the bank accounts of about 20 entities. That judgment was handed down on the 4th of February, as I say. We were really pleased that we were able to put out a case to the special tribunal, which forfeited all these unlawfully acquired monies back to the state. So the instruction I have given to the legal team is that now, more than ever, it's urgent to convert these orders into an execute, where we execute to ensure that the monies are obtained as ordered back to the state, in this case, Department of Health. The next case is still in Gauteng. It's related to the activities that were reported in the above case. This is where we have freezed the pension fund of the CFO. This matter, the next slide. This matter is scheduled to be heard, Honorable Chair and Honorable Members. It's scheduled to be heard, the last line on that slide, from the 1st of June 2021 to the 18th of June 2021. This is where we will all then, all the parties present to the special tribunal. We will be saying that those pensions should remain freezed until this matter is finalized, and there we will then deal with the damages caused that we have presented to the special tribunal. Next slide, 32. Moving to KZN, the Department of Social Development against certain companies, Rosette Investment, Gibela, and LNA Communications. The value of the contracts are mentioned there and the dates instituted. The matter relates to the irregular procurement of blankets for the Department of Social Development in KZN. The investigation revealed that, in fact, less blankets were distributed than the department had in its store prior to embarking on the procurement process. Civil proceedings have been instituted against the suppliers in the special tribunal to review and set aside the award and the resulting contracts to the value of more than 18 million. and to recover the losses suffered by the department. At a national level, again, this is the matter that has been ventilated at the special tribunal, and the portfolio committee, the Scopa is aware of this matter. This relates to the Bay Bridge border fence. So we then enrolled the matter to cancel the contract to the value of about 40 million. Now, the respondents came back and then raised an issue relating to the jurisdiction of the special tribunal. That matter was held on the next slide, was held on the 26th of January 2021. That's the last sentence. The judgment was reserved. We're hoping, we have presented to the special tribunal that it does have jurisdiction to hear these matters, but of course, it is the prerogative of the other parties to raise any legal point available to them. So they thought it appropriate to raise the jurisdiction matter. We are waiting for the judgment to be delivered. As at the 25th of November 2020, the total value of matters in the special tribunal was 259 million. We made a note, Honorable Chair and Honorable members, that as at the 4th of February, there has been 15 matters enrolled in the special tribunal to the contract value of 365 million. So those matters has since, the number of matters have since increased, and you can see the value, the contract value has also increased, and we will ensure that we follow up and execute on these matters in the special tribunal without delay. That brings us to the end of the matters that are in the special tribunal. The next slide. Honorable Chair and Honorable members, this can be found on page 37 of the actual report. Often there has been a general outcry about the involvement of domestic prominent influential persons as defined in the Financial Intelligence Center Act and their immediate family as defined by this Act, benefiting from the PPE procurement by the state institutions. We've found these allegations in various provinces that so-and-so would have received a contract because he or she is associated with a certain prominent member. So we looked, I asked our legal team to look into the legal provisions relating to this aspect, and this is what we have found. Currently, such involvement of the person associated allegedly with a prominent person does not necessarily render the awarding of the contract to such people or entities that they're involved in unlawful, and such contracts must be scrutinized for compliance with the principles of Section 217 of the Constitution, the PFMA and MFMA. So that's what the investigating teams have done against the requirements of that contract being awarded. Now, there exists for considering the need exists for considering additional safeguards for situations where state institutions contract with persons in these categories. The FICA currently regulates the conclusion of contracts between accountable institutions and domestic prominent influential persons and their immediate family. But the schedule listing accountable institution does not include state institutions such as national, provincial, or municipal, or even state-owned entities. In addition, FICA only envisages the remedial actions through administrative actions. FICA also does not create statutory offense if its provisions are not complied with. FIC has since reached out to us, to SIU, to seek to discuss this aspect, and we're hoping that there will be processes in place where we can put forward our observations, and then the legislative process can take its course and the required safeguards can be put in place. Thank you. Next slide. Right. So this is the part I've covered. We are saying that we recommend that legislative amendment be considered to provide for safeguards when state institutions are to contract with domestic prominent influential persons and their immediate families, as well as entities in which they have an interest or a beneficial owner. As such, all the state institutions should be bound by those safeguards once they are introduced. We do not, however, suggest that the mere fact that someone falls in this category would render the contract unlawful, but it should be a prerequisite of all supply chain management processes that a disclosure must be made that a potential service provider falls within the category as set out above, and then the checks and balances can be implemented in terms of the legislation so that this outcry can be mitigated. So if those measures are in place, failure to make such disclosures must then be made unlawful and should constitute statutory course of action to attack the validity of the process. Intentional non-compliance with such prescripts should be made a criminal offense. Thank you. Next slide. Honorable Chair and honorable members, the next slide deals with another outcome that we've presented above. This deals with the number of referrals for disciplinary actions. These are the referrals that we have already made to the state institutions. And it's really going to be very important that we follow up, and probably the Scopa could also assist in ensuring that the departments mentioned are held to account in terms of making sure that there's consequence management. That's our plea. But up to now, we've got about 25 employees that have been referred. Right. If I start off in the Free State, we've referred one official. It was already referred on the 9th of November. That referral refers to a senior manager. We are currently assisting the provincial treasury with this matter. Gauteng Department, one middle manager. The SIU already met with the evidence leaders appointed in the matter, and the matter is set down to be heard on the 15th of March. We are pleased that there's progress in this one. Gauteng Department of Health again, one referral against another senior manager. The SIU again met with the evidence leaders appointed. The disciplinary hearing was already scheduled from the 11th to the 15th of January, but it was postponed following an application by this senior manager for further investigation. The new date for the disciplinary hearing is already scheduled, and we are pleased about that. The SIU will follow up on the outcome of the hearing. Gauteng Department of Health, again, two further referrals of other senior managers. The official resigned from the department on or about the 3rd of October. Now, as we have already been on record, that when you resign, you might just terminate the employer-employee relationship, but we will ensure that you are pursued civilly and criminally where evidence points to that. And this is a typical case where we have freezed the pension, and now we are continuing with the civil suit for damages. Related to the Gauteng matters, there's one referral to the presidency against the spokesperson of the president. SIU was informed that the office of the president is reviewing the evidence submitted and will be taking relevant steps. We've been informed that the presidency took a decision to implement the disciplinary process, and as we speak today, our assumption that process is underway. Department of Education, there have been 6 referrals of senior and middle management. The SIU has been in contact with the department, although the department is at various stages of actioning the recommendations. None of these matters have been finalized to date. That's an aspect of worry, but we will follow up on the outcomes of these hearings. In the Sekhukhune municipality, this is in Limpopo, we have made 5 referrals against senior and middle management. 4 of the officials are on the suspension pending finalization of the disciplinary process. 1 official resigned before being served with a letter of suspension. The disciplinary process is delayed due to COVID-19 infections within the municipality. The team established at the time, but however, they will follow up on the outcomes of this hearing. Mpumalanga, Department of Health, there's been 2 referrals of senior and middle management. In this case, the HOD informed SIU that the referrals have been sent to their lawyers for review and decision on the way forward. We will again follow up in this matter. Northwest Department of Education, 2 referrals of middle manager and administrative clerk. Proceedings in respect of 1 referral were scheduled to begin on the 18th of December, but have been postponed to a date to be announced later. Proceedings in respect of the other referral have not yet started. SIU is awaiting a response from the department, so we will continue to follow up on that. Ratho Municipality, 2 referrals against senior and middle management. SIU held a meeting on the 28th of January with the newly appointed administrator, and she undertook to fast-track the process. In JB Max Municipality, there's been 2 referrals of senior managers. In this municipality, a law firm was appointed to deal with 1 of the disciplinary referrals. The SIU consulted with the law firm on the 19th of November, and the second meeting will be scheduled in February now for the hearing, so that the hearing can continue. We've also interacted with the appointed MEC of Coxter, who undertook to follow up on these matters. These matters on slide 37 are in pages 31 and 32 of the actual report. Those are the referrals for disciplinary hearing. Now we deal with the referrals to the National Prosecuting Authority, and those matters can be found on pages 33 to 34. The evidence has already been referred. So in the Eastern Cape Department of Health, there's been 2 referrals against a senior manager. The offense is corruption. A criminal case has been opened, and there's a case number 8 September 2020 is under investigation by the Hawks, and the SIU is collaborating with the NPA and the Hawks. In this case already, an NPA prosecutor was assigned to this matter. In fact, on all the matters that follows, the NPA has already provided a prosecutor, and we are really pleased by that, because that is going to afford the opportunity for these matters to be progressed quickly. So in the OR Tambo municipality, there's been 3 referrals against senior management, 1 of the entity and the director of the entity. The offense is fraud and contravention of section 61(1) and section 173 of the PFMA. A criminal case already under investigation by the Hawks. The Hawks arrested a director of the service provider and 1 of the senior managers. The criminal case was remanded. It already appeared in court, was remanded to the 15th of February. We will follow up on what happened on that day. It's still to come. Today is the 10th in 5 days time. The NPA prosecutor was assigned to this matter. Free State Provincial Treasury, 6 referrals were made against senior management, 1 entity and the CEO of the entity. Again, the offense is fraud. Criminal cases were registered and are currently being investigated. Again, in this matter, a prosecutor has been allocated. Gauteng Department of Health, there's been 2 referrals of senior managers. The offense is financial misconduct in terms of section 86 of the MFMA. A criminal case was opened in Johannesburg, and the matter is under investigation by the SAPS. Again, in Gauteng Department of Health, 2 referrals against the entity and the director of that entity. The offense is fraud. The case was opened and is being investigated by the SAPS. The Department of Social Development, 1 KZN, Department of Social Development, 1 referral against the senior manager. The offense is misconduct. A prosecutor has been assigned to the matter. Still in KZN, Education Department, 9 referrals, 3 entities, their directors and managers. The offense is fraud. A prosecutor has since been assigned, and the SIU has met with NPA and DPCI for the briefing on this matter. The SIU is providing an ongoing support to the prosecuting team. In the Sekhukhune district municipality, there's been 2 referrals against middle managers. The offense is fraud and financial misconduct. The NPA has assigned a prosecutor. Ratlo municipality in Northwest, 1 referral against senior manager. The offense is financial misconduct. The matter was referred back to SIU to finalize queries, but those queries have since been attended to. We send them back on the 3rd of February. JB Max, local municipality, 1 referral. The offense is financial misconduct. This matter is still under review by the NPA. The Western Cape Department of Environment, Forestry and Fisheries, there's been 2 referrals. The offense is fraud, alternatively forgery and uttering. A criminal case was opened at the central, at Pretoria Central. This was a bit of an anomaly. It appears that the contracting process also was done in Pretoria in the department. So Chair, we're really ensuring that it should really read the Department of Environment, Forestry and Fisheries. For this is at a national level, and hence it traverses the 2 provinces. So we apologize for that. In fact, the Western Cape Department reached out to us after the report was released and said they do not have a Western Cape Department of Environment and Forestry. So we are in the process of correcting that. We apologize for it. The next slide, 39. Gauteng Department of Health. Sorry, Chair, just to clarify. Slide number 38 deals with the number of referrals made to the National Prosecuting Authority. That is the number, and I think the number of referrals come to about 38. So we will follow up on those matters. We'll follow up with NPA. We'll support the investigations as we need to do. Now, the next slide on slide 39, that deals with the referrals that we refer to as needing executive or administrative action. This deals with the people who are in charge of state administration, but they are not employees as defined in the Labor Relations Act. This could be your MECs or office bearers in the municipalities. So in the Department of Health in Gauteng, given the irregularities that we found, we have made a referral against the former MEC. And as we speak, the former MEC has taken the findings of SIU to. That matter was heard on the 21st of January 2021 before a full bench. A judgment was reserved on that day. So we await the judgment, Chair. This is going to be quite an important case or outcome, which would then define the accountability between the accounting officer or authority and the executive authority. It's important that part is really, really clarified, and the court will give us judgment on that. In the JB Max municipality, there's been a referral against the office bearer. The disciplinary referral was made in respect of the awarding of a donation to an entity. again, the MEC has undertaken that he will follow up on this matter. So these matters, as I indicated, are on page 34 and 35 of the actual report. Slide number 40, please. These matters, Honorable Chair and Honorable Members, can be found on page 35 to 36 of the actual report. These are the matters that SIU, during its investigations, often against certain individuals or service providers, and the service providers then come forward, having acknowledged and makes offers to settle the debt or whatever we could have found. And in this regard, we then interact with the state institution concerned. We don't just finalize the matter. If between SIU and the state institution concerned, we are satisfied that that is the amount due and payable, so that we don't go the litigation route, that is then accepted, reduced either into an acknowledgement of debt or acknowledgement of liability, and then we follow up on the payments. Another avenue legal avenue that we follow is that if we become aware during the investigations that there has been irregularities relating to a certain contract, we then approach the department to stop payment towards service providers. Don't just do that. The stoppage of payment is subject to SIU instituting civil proceedings to ensure that those contracts are aside and the amounts are stopped. So that example is the one at the top of the list. Gauteng Department of Health. We recommended to the department to stop payments of 5 service providers to the value of 116 million. The department have confirmed that no further payments were made. And SIU then is going through the civil proceedings to ensure that a proper court or tribunal order is obtained. Department of Health, this one relates to the matters or amounts which were forfeited to the state. Remember, these were freezed amounts, and they were ultimately forfeited to the state, and so we have recorded it here as one of those potential amounts that became actual after the forfeiture order. Gauteng Department of Health, about 247,000 acknowledgement of debt was signed. The service provider was contracted to supply surgical masks, and irregularities were found with that contract. The contract value is 7.2 million. The AOD was signed because an overpayment in respect of VAT. So the investigation may not have revealed irregularities in the procurement process, but we found that there was an overpayment of VAT, and the acknowledgement of debt was signed. Of course, the team will have to follow up with the payment and ensure that it's paid back to the state. KZN Department of Education, 3 AODs were signed for the under-delivery of goods supplied and for the overcharging of the Department of VAT. 3 service providers were contracted to supply PPE with a cumulative value of 15.1 million. 1 AOD was signed to the value of 176 and has been repaid in monthly installment. To date, about 44,000 has been paid. The other AODs totaling more than 1 million have been repaid in full. So, and the repayments would be done in the process where they are paid either directly to the department, or if they are paid to SIU, they are kept in a trust account, which is then transferred over to the state institutions. The trust account, just for the record, is ordinarily as the affairs of SIU are audited, is ordinarily regularly audited. KZN Department of Social Development, recommendation was made to the department to withhold payment of service provider. The department has confirmed that no further payments was made. Again, this one is also subject to civil proceedings. The KZN Department of Social Development, about 276 AOD was entered into. The service provider were not registered as vet vendors. The service provider was contracted to supply PPE, and the value of the two contracts was about 2.5 million. In Mpumalanga, an acknowledgement of debt was made to the amount of 76,000 because the service providers inflated the prices of PPEs, and the debtor is making monthly payments which are monitored. Again, in Mpumalanga, further two acknowledgement of debts to the amount of 150,000 AODs were signed. Again, the investigation revealed that the service provider inflated the prices, and those AODs, both these AODs, have been repaid in full. Northwest Department of Health, an acknowledgement of debt. Two acknowledgement of debts were signed based on the fact that the investigation revealed service providers were paid VAT but were not registered. Matikama local municipality, this is in the Western Cape. A recommendation was made to withhold payment to one service provider, and the department or the municipality confirmed that the payment was not made, and the SIU is finalizing this matter, including going to the special tribunal. The next slide. Honorable Chair and honorable members, this slide just provides the updates since the 4th of February, and I think I've already spoken to that. It's not in the report itself, but we thought it appropriate just to update the committee on the activities since the 4th of February. As we indicated, as on the 4th of February, the special tribunal handed down judgment, and approximately 7.4 million actual now was forfeited to the state. So the above figure that we've shown of 26 million was the potential recovery, but at the day of the judgment, after some computations were done, the actual amount was 24 million. The contract was set aside to the tune of 139 million. So if you take out the 24 million, which was forfeited to the state, there was also still another 100 million, which was not paid yet. Had the contract gone further payments would have been made, so the 100 million was saved. So the remainder of the amount is the ones where the contract, the special tribunal made computations, and those were some of the amounts that were released. As we say there, the loss prevented was in the tune of about 100 million, and some of the amounts were forfeited. Next slide. Honorable members, this is in page 38 of the actual report. As we did the investigations, we also looked at the UIF. In this case, we were approached by the department and the ministry to conduct the investigation. But because the matters did not fall within the proclamation as our teams assessed them, we did the investigation based on the secondment, because it's one of the legal avenues that the SIU has to conduct the investigation. During the secondment, we worked closely with the SAPS because there were matters that were found to have been irregularly paid. A total of 75 criminal cases have been opened and are currently under investigation. We used the information that we obtained in this period to prepare for the proclamation so that a proclamation could be signed off to incorporate these matters. They can be investigated at length. But we've seen that the Auditor General has also looked at these matters and produced a report, which we have gone through. So as we speak, we are engaging the department because the secondment has come to an end on the 15th of December. We would like to re-engage with them so that there is no lapse. And the teams are already engaging. We might sign the new secondment agreement so that the investigation continues, albeit on a secondment pending the proclamation. The next slide. Honorable Chair and honorable members, these matters, we did not go into detail with them when we released the report on the 5th of February, but we thought it appropriate that we could go into them with the committee. The matters are in the actual report, and we do relate from page 38 onwards. It's really the details of those matters that have been finalized. In other matters, no irregularities have been found and the matters have been closed. Honorable Chair, I would like to assume that if I still have time, I can go through them. It won't take a long time to do that.
Before you proceed and do everything you need to do, we are scheduled to be here until 13:30.
Oh, great! Thank you very much. We will go through these matters that have been finalized in the Gauteng Department of Health, and I'm referring now to page 38 of the actual report. Allegations were received on the 5th of June 2020 in respect of the irregular procurement contracting for supply of e-recruitment. The e-recruitment part is on page 38. In that investigation, there were irregularities found, and the steps taken are shown on page 39. There has been one referral made against an official for disciplinary process. Some of these referrals for disciplinary process are the ones that are included in the referrals that I was reading above. Radiography material. Honorable members, on page 39, there's also a matter relating to boot covers, gloves, backpacks, spray bottles, and so on. In this matter, which is on page 39, no irregularities were found. The radiography matter is on page 40 of the actual report. In that investigation, the allegations were referred to the SIU by the Gauteng Office of the Premier on the 5th of June. It relates to the procurement of and contracting of the supply of radiography material. In this investigation, SIU found no irregularities. The allegations could not be supported or substantiated. The matter is closed for that purpose. PPE related goods and services that can be found on page 40 of the actual report. Again, the allegations were referred to SIU by the Office of the Premier. In that investigation, the allegation related to the procurement and contracting of goods and services by the Department of Health to some named service provider. However, based on the allegations, it was not clear what type of goods and services were procured. As the investigations unfolded, the investigation team could not find evidence that substantiate the allegation, so the investigation is closed. On page 41 of the actual report, there's also a report there which we did not really include on the slide, is on the medical services for mentally disabled patients. I thought I would cover that for comprehensive sake. The allegations was referred again by the Office of the Premier. It relates to the procurement of contracting of supply of medical services. So in this investigation, all relevant documents were obtained, and the investigating team found that the Department of Health actually complied with the relevant legislative requirements. The matter has since been closed. Now, on the matters on the slide, the next one is the computer equipment. That is found on page 41 of the actual report. That relates to the allegations referred to SIU by the Office of the Premier. It relates to the procurement and contracting of supply of computer equipment by the Gauteng Department of Health to the tune of 452,000. The investigations found no irregularities in that. In those allegations, they could not be substantiated. The warehousing services, that is on page 42 of the actual report. In this case, the investigation found that the services were actually not provided, and the SIU has since closed the report. Still on page 42, which is not on the slide, we apologize, but for completeness sake, it refers to the purchasing of surgical gowns. It's on page 42. So the allegations were again referred by the Office of the Premier relating to the procurement and contracting for provision of surgical gowns. All the documents were obtained and the supplier and the interviews were conducted. And then the investigating team find that the price of the surgical, the same as indicated on the transversal contract. The surgical gowns were accepted and delivered to the relevant facilities for use. So there were no irregularities found. Now on the eight service providers were appointed. Bear with me, Honorable Chair. This relates to the contract to the value of 1.1, which was awarded to the 4 service providers, and we found that the remainder did not do business with the department. I'll just make an asterisk on this one and indicate on which page is the actual page of the actual report. As we move forward, page number or slide number 46, Department of Education in Gauteng. That is on page 42 of the actual report. The allegations was received on the 1st September 2020 in respect of the irregular procurement of and contracting of the supply of PPE related goods. The allegations was against one service provider. SIU investigations found that the service provider did not do business with the department, and the matter is closed. The Southwest TVET College, that is on page 43 of the actual report. The allegations were received from a whistleblower in respect of the irregular appointment of service providers at the college. the investigation was conducted. At the college, it was established that no PPE services were procured by the college during the lockdown period, so the allegations were not substantiated. Still on page 43 of the actual report, this is the City of Johannesburg. An allegation was received on 1 September 2020 in respect of the irregular procurement of and contracting for the supply of PPE related goods and services. The allegations referred to contracts valued at 18 million, but the investigation revealed that the service provider actually did not enter into contract with the City of Johannesburg. So that the investigation is now finalized and found the allegations as unfounded. The next slide, page 47. The National Department of Public Works and Infrastructure. That is on page 44 of the actual report. No, it starts from page 43 on to page 44 of the actual report. But this is the matter that is featured on the agenda of this committee. It relates to the Bait Bridge border fence. I've already covered it when I referred to the matters in the special tribunal. Here, the irregularities were found, and the special tribunal is seized with this matter. As I reported above, that the contractors are now challenging the jurisdiction of the special tribunal. South African National Defence Force, that is on page 45 of the actual report. An allegation was received on the 1st September 2020 in respect of irregular procurement and contracting of the supply of PPE related goods and services, and there was also an allegations of collusion. The allegations referred to contracts valued at 1.3 billion. But again, the investigation revealed that there was no contracting to that value. What the investigations uncovered, and is covered in the report, is that the invoices that were presented to the investigators, when they investigated, it appeared that the invoices were generated externally, fraudulently, and they were presented to service providers as though they were presented by the National Defence Force. So that was found, and the service providers actually called the National Defence Force to verify, and that's where they realized that no, the invoices were false, and no payment was made. There was no contracting. However, I'm informed by the investigating team that this matter is under investigation by the military police, because there's indication of a syndicate here. So that aspect could not be left unattended. I indicated to the team that they should support the military police to ensure that that matter is investigated appropriately. Next slide, slide 48. We move now to the matters in the Eastern Cape. In the Department of Health, this matter I've already covered when I dealt with matters in the special tribunal. This is the so-called motorbike matter. The payments were stopped in the special tribunal. We are going to the special tribunal to set aside the contract. The OR Tambo, and again, the Department of Health matter is on page 47 to page 48 of the actual report. The OR Tambo District Municipality is on page 49 to 51 of the actual report. Again, Honorable Chair and Honorable Members, I've covered this when I dealt with matters in the special tribunal that were presented there already. Irregularities were found, and we are at court now to set the agreement aside. The Amatole Water Board matter is on page 51 to page 54 of the actual report. In this matter, the allegations was received in respect of irregular procurement of the installation of water tanks. 36 service providers were awarded contracts to the value of 553.7 million. On page 53 of the actual report, Honorable Chair and Honorable Members, we are showing the steps taken because the investigation revealed irregularities. So to date, we have briefed counsel and the drafting of the papers is underway. Civil proceedings will be instituted in the special tribunal against the 15 service providers. And SIU will make an application wherein it seeks the setting aside of the contract of all those service providers and seek to recover the monies that have been paid out. Now I move to the next slide 49. Did I skip? No, sorry, excuse me, Chair. The Nelson Mandela Metropolitan Municipality on slide 48. And this is on page 48 to 49 of the actual report. And allegations was received on the 26th August 2020 in respect of the irregular procurement process for infrastructure project. One service provider was awarded a contract to the value of 24.6 million, and this matter is in the special tribunal because we have found that the contracting process was irregular for recovery of the money spent by the department. Next slide, 49. The Department of Public Works and Infrastructure, those are on pages 45 to pages 46 of the actual report. The Department of Public Works and Infrastructure in the Eastern Cape, an allegation was received on the 24th August 2020 of fraud and fronting in respect of the renovations of 4 buildings at the Dora Nginza Hospital, the cost of 33 million. The investigation was conducted and it found no irregularities in respect of the procurement process, and the service provider had complied with all the tender conditions. Department of Public Works, Steel, Infrastructure, and allegations was received on the 31st of August 2020 in respect of a contract for the supply of PPE goods and services that was awarded to a deceased person. The SIU, however, found that the newspaper had incorrectly referred to the deceased person's company as having received the tender. So that allegations was unsubstantiated, as it was not confirmed. I move over, Chair, now to the matters in the Free State Province, slide number 50. All of those matters can be found in page 54 to page 61 of the actual report. These are the allegations which were received on the 5th of August and 17 August 2020 in respect of irregular procurement and contracting for the supply of PPE related goods. Seven service providers received contracts to the value of 26.8 million. In four of these matters, it was alleged that the contracts were awarded because the service providers had a close relationship or were associated with domestic prominent influential persons. However, these allegations could really not be substantiated, could not be founded. We found that they were unfounded. So in all of these matters, the investigations was conducted, looked at the procurement process, and no irregularities were found relating to the procurement process. The specific allegations relating to association with prominent people was unsubstantiated. So all of those matters, Honorable Chair and Honorable members, are found on page 54 to page 61 of the actual report. If I move over to KwaZulu-Natal, the Department of Education, this is one of the matters that we have already indicated. It's found on page 62 it starts on page 61 to 62 of the actual report. An allegation was received on the 30th in respect of irregular procurement and contracting of PPE related goods. 18 service providers received contracts to the value of 6.8 million. We've already found irregularities, and in this matter, there are already 3 NPA referrals of 6 officials for misconduct, and referrals to SARS. All of these referrals have been covered in the referrals that we referred to above. Department of Education, in the KZN again, on page 61 to page 62, an allegation was received on 20 September 2020 in respect of the irregular procurement process for the supply, delivery, and installation of water tanks. It was alleged that 41,000 water tanks were procured at a cost of 28,000 per tank. A total cost was 1.1 million. The matter has been referred to the SIU national team because the procurement was centralized under the National Disaster Water Command Center. So this falls under the ongoing investigation, and it's been receiving attention by the National Investigating Team. We will find out at the next project review how far they are, and if completed, it will be in the next interim report to the President. The Department of Social Development, this is in page 66 of the actual report. These were allegations received on the 30th in respect of irregular procurement for the supply of related goods. 16 service providers were contracted to the tune of 21.2 million. Irregularities were found, and if you look on page 66 of the actual report, steps have been taken. A case has already been opened on receipt of the Treasury forensic report. In this investigation, the department and the province had already commissioned a report, which was done by an independent service provider, and that's why we refer to it as the Treasury forensic report. And some steps were taken. We are ensuring, because we did not want to duplicate the services that have already been rendered, but my instruction to the team in KZN is that they need to satisfy themselves that the forensic investigations coverage was appropriate and appropriate action or outcomes have been reached. So there has already been a case opened, a referral was made to SARS, and a criminal referral has been made to NPA. And we have already briefed counsel now so that these matters can be taken to the special tribunal to recover the funds. Those steps taken, as I said, can be seen on page 66 of the actual report. The Department of Social Development in KZN, that is on page 64 to page 65 of the actual report. This relates to the allegations which were received in respect of the irregular procurement of blankets. 4 service providers received contracts. The investigations found irregularities, and steps taken in this regard are on page 65 of the actual report. Already there has been referral to SARS. Recommendations were made to the department to stop further payments. And again, as I said, all of these steps taken are included in the referrals or the outcomes that we have reported above. Evidence for criminality has been referred for investigations. There's case number 228/7 of 2020, and the investigation has been completed and moved from our side, moved to the support phase where the litigation and criminal prosecution would be supported. Right, the next slide. Is Limpopo Province. The Sekhukhune District Municipality, we've already reported on it when we covered the outcomes. The allegations were received in respect of irregular procurement of services for boreholes and water supply. 8 providers received contracts to the value of 26.3 million. In this regard, we need to credit the municipality that they acted and secured an interim order on the 21st of July from the Limpopo High Court to set aside their appointment letters. But of course, this is after they became aware that SIU was investigating, and already the investigation was underway. Irregularities were found and steps taken, Honorable Chair and Honorable Members, that can be found on page 69 of the actual report. Already there has been, and these are covered in the outcomes above, 5 officials referred for disciplinary process. A criminal case was opened. A criminal referral was made to the NPA. So we're glad that it has reached that finality. We'll monitor the outcomes. The Department of Health in Limpopo, an allegation was received in respect of irregular procurement and contracting for supply of PPE related goods and services. 1 service provider received a contract, that was the allegation, of 16 million. However, after the investigation, the SIU investigation found no irregularities, and that the service providers were actually licensed by SAPRA to supply the medical services. SIU did reach out and checked with SAPRA to make sure that the finding is returned. Next slide. In Mpumalanga Province, these matters of Mpumalanga, the team there investigated matters in the Provincial Treasury, Office of the Premier, Mpumalanga Parks and Tourism Agency. Those matters are all documented in pages 69 to page 76 of the actual report. And Honorable Chair, you'll see that in all of those investigations, the investigating team, after having gone through the investigations, found that there were no irregularities. However, as we mentioned above, that there has been 1 referral by Mpumalanga team relating to Mpumalanga Parks. That relates to some of the irregularities that could have been picked up during the investigations in this Mpumalanga Parks and Tourism Agency. So Chair, I'll not go through all the matters on page 69 and page 76. There the investigations were conducted, and in all of them, no irregularities were found. Allegations could not be substantiated. Okay, that takes me to Northern Cape. Again, the Northern Cape, one allegation was received that related to the procurement of PPE by the South African Police Service to the tune of 13 million, because the service provider had close relationship with a domestic prominent influential person. The investigation, the service provider failed to supply the PPE, and the SAPS cancelled the contract and no payments were made. In this regard, that is the ultimate finding of the investigations. There was no contract entered into. There were no irregularities found, particularly relating to the procurement process. Now it moves me to slide number 55, dealing with the Northwest Province. The JB Marks local municipality, that's on page 77 to page 78 of the actual report. I've already reported on this JB Marks municipality, Honorable Chair, above when I covered the referrals. An allegation was received in JB Marks in respect of a donation, and we have reported up there that already irregularities were found, and we have already made a referral against an office bearer. JB Marks, an allegation was received in respect of irregular procurement and contracting of the supply of PPE related. 33 service providers received contracts. We've already briefed and instructed council to initiate proceedings for setting aside of the contract. Rato municipality, there were allegations relating to the procurement of contracting of PPE. The investigations found that the allegations could not be substantiated as the supplier had not overcharged the municipality. Northwest Department of Health, and allegations was received in respect of irregular procurement of and contracting of PPE related goods. It was alleged that 2 service providers received contracts to the value of 8.5 million. The SIU investigations found that one service provider that the allegations referred to actually did not tender for the PPE, and there were no irregularities found in this investigation. In the Ramo Tseremila local municipality, an allegations was received in respect of food parcels. In this regard, SIU was unable to substantiate the allegation because the whistleblower failed to provide further investigation or further information. As such, SIU was not in a position to conclude a proper assessment of the matter against the jurisdictional requirements of 2.2 of our Act. In Western Cape, that takes me to slide 56. In the Department of Health, allegations were received on the 6th of August in respect of irregular procurement of and contracting of PPE-related goods and services. One service provider received a contract, that was the allegation, to the value of 9.9 million. The SIU investigations found irregularities, but recommendations were made to inform the system improvement that were found in that process. In the Department of Environmental Affairs and Development Planning, an allegations was received on 13 August 2020 in respect of the irregular procurement of and contracting of the supply of PPE-related goods and services. One service provider received the contract, and the SIU investigation revealed no irregularities. The Office of the Premier, an allegations was received on the 13th of August in respect of irregular procurement and contracting of PPE. One service provider received a contract to the value of 216,000. The investigations found no irregularities. The Department of Education, and allegations was received in respect of procurement and supply of PPE. One service provider received a contract to the value of 73.7 million. Again, the investigations revealed no irregularities in that regard. Honorable Chair and honorable members, that brings me to the conclusion of the presentation of the report. And as we say in the conclusion, while the investigations are still underway, this is the report, Honorable Chair and honorable members, that we present relating to the finalized matters and the outcomes that have been reached and the actions that require to be taken. So while these investigations are underway, we will continue then to submit the reports to the President as required. The next interim report, will be submitting it in February. We continue to execute on the outcomes and follow up on referrals to ensure that there is consequence management. And this is where we plead with the committee that as the departments from time to time appear in the committee, such inquiries could be made in terms of executing on the consequence management. We are focusing on ensuring that there is accountability at all levels, Honorable Chair and honorable members, of the administration, including executive authority accountability. Our collaboration and cooperation with other agencies in the Fusion Center has proved valuable. The NPA has provided prosecutors to guide criminal investigations, and we are assured that they will prioritize consideration of these matters. Honorable Chair and honorable members, the Special Tribunal has proved to be of critical importance in the speed up of civil litigation instituted by the Special Investigating Units. As we indicated, that we don't really need to go to the high courts anymore, and we are seeing the value of the Special Tribunal. We will take all steps necessary to ensure that losses suffered due to irregularities, corruption, and maladministration are recovered and returned to the state. The comment I made earlier on, the legal team of SIU is on instruction to ensure that as we get the orders, we immediately pursue the execution of these orders to then recover the monies lost by the state. Honorable Chair, I'm thankful that we were given this time to present to Scopa and present our report to Scopa. That brings me to the end of the presentation. Thank you very much.
All right. Thank you very much, HOU, in what has been a marathon presentation. Charles Dickens speaks about it is the best of times, it is the worst of times. I think the former can fall away. It's quite clear that it is the worst of times. It is just seemingly a total disregard for due process and a very tragic erosion of the state's machinery to govern within the parameters of the law. There's just a systematic collapse, actually, and people who are hell-bent on undermining the public purse. So I'm seated here, not shocked, because we've been going through this for, well, from Friday we've presented your report, we've interacted with you, but every time you hear it, it still unsettles you. And the detail at which you have actually gone through HOU is quite appreciated. I think, colleagues, we will have to apply our minds in terms of how we process this. I will probably make a few suggestions for your consideration at the end of the question and answer session in terms of how we will move forward with all of this. But quite clearly, we've got our work cut out, but I've got no doubt also that we are equal to the task. So let's go to questions. So maybe what I'll do, colleagues, because the matters are a bit complex and some of them may get lost, convoluted. Because we've got time, I see the list. How about I give a member 5 minutes each in the list that we have, back and forth with the SIU, and then they finish, and then you move on to the next member so that we dispense with the matters cleanly and properly. The one thing, HOU, which I'm just asking now that your team works out is how much is all of this costing the SIU? Because the cost to corruption, the cost of corruption is the resources, knowledge, skills, and expertise that have to be used to now pursue these matters on one hand. But there's the financial implications and whether you are receiving what is due to you from whomever it is due from. Because we have to have a keen appreciation of the gravity of what corruption does. The cost of it are astronomical, to say the very least. So I'll just ask your team in the meantime, because it's not part of this presentation, to just work it out and give us that figure at the end so that it can continue to raise the consciousness of all of us as to why it is crucial that these things are avoided and that they're not done. There is the money that we spend to recover money in itself could be used elsewhere if these things don't happen. So, right, Honorable Liz, you'll be first off the bat and you'll have 5 minutes. Honorable Van Minen, Honorable Mente, Honorable Tolasha, Honorable Hatebe, Honorable Zibola, and Honorable Somyo, in that order, please, of all members in 5 minutes each. So Honorable Liz, you can do a back and forth and just get the clarity to your questions properly, and then Honorable Van Minen will come in and then we'll continue with the sequence. I'll be timing. All right, shoot.
Thank you, Mr. Chairman. Yeah, it's a very big subject, and thank you to Advocate Matibi for the presentation. I think in the course of the evolution of history, it may well be written that this corruption by both officials and associated businesses will come in time to be looked upon as a crime against humanity. It is so evil in the bigger sense that it really does deserve to be dealt with in the most robust way possible. And so, Mr. Chairman, my first question to Advocate Matibi is a kind of follow-up on your question, because before the COVID-19 pandemic and the subsequent work that the SIU has been involved in there, the SIU already had an overload of work. And I need kind of comfort from you, Advocate Matibi, that the work of the SIU in general is progressing, as well as clearly this work is progressing given the details of your report. So where do we stand? We've giving 10.5 billion rand to SAA. As the chair has indicated, are we allocating sufficient resources to you and your team to do the job properly, not just on the PPE, but the many, many issues? Because what is of major concern to us is the very slow pace of prosecutions and convictions. They seem to happen very, very slowly, and I'm not just referring now to the latest PPE ones. So, Advocate, in terms of resources, we know that the NPA is horribly under-resourced. The entire annual budget, if I remember correctly, is about a quarter of what the latest allocation to SAA is. What is your situation and your team in terms of being able to cope, not just with PPE, but with all the cases that you're dealing with. Thank you, Mr. Chairman.
Right, let's get a response, and then Honorable Van Minen will be next.
Okay,
Honorable Head of Unit.
Thank you, Honorable Chair. On the costing, Chair, we will, as you requested, we will work on that. I've just asked the CFO and the reporting team to cost, and we will indicate a figure. The way we'll work it out is that as we enter into investigations, we also allocate resources per investigating officer and the level, and we cost the level of the resource allocated in relation to the rates that SIU charges. So the figure that we will come to will be an indication of that work that we do. The other cost, and I mean, the head of legal is in here, over and above the cost of investigations that we charge, I think we also need just an indication from our head of legal, perhaps at the end also, to show, because Honorable Chair, you are saying the money that it costs, that we spend to recover. So we need to give the Scopa an indication of the legal costs as well. So we'll do that. With regard to Honorable Liz, with regard to the workload, yes, indeed, we do have other projects that are running, notably the SAA, ESCOM, Transnet, and others in Dinel. So what we have done was to try our level best to reallocate the resources from other projects to deal with this COVID-19, because it came at the time and attracted such huge public interest. It was incumbent on us to turn the investigations around as quickly as we could. Lives were at stake here. The PPE that had to be procured put lives of workers, be it health workers or any other frontline workers, at risk. The other matters or other COVID-19 procurement for infrastructure and the others, those irregularities attracted so much public interest, and we were enjoined to turn around this investigation as quickly as possible as we did. And hence we are able now to present to Scopa the results of those investigations. Of course, it's still ongoing. Now, the issue around the resources, this comes at a stage, and Chair and honorable members, Honorable Liz, we've been on record saying, you know, the resources could be improved. And that is why in the budgeting process, we submitted our resource requirements through the Department of Justice to National Treasury, because we spec'd out, we projected our resource requirements. We did that even before COVID. With COVID, we just had to revisit. But we saw an increase in the proclamations, and we had to make sure that we revisit our cost resource requirements. So we've done that and presented it. But with the fiscal constraints that we have now been visited on, I mean, our CFO can indicate that we've actually not escaped the cuts of the budget like any other state institutions. So we're still on the hope that the National Treasury through Department of Justice could respond to our resource requirements or as we presented to them. So how does this affect now the current other proclamations or other investigations? We do have teams that are still in those other investigations, and you could see that we still are able to report on ESCOM. We will be able to report on SAA. Of course, in those investigations, we are not honestly moving as quickly as we would have wanted to had it not been for allocation of resources to the COVID-19. But what are we doing to mitigate that? We do have a panel of service providers that we have put in place, and we've been on record as saying we know that it's pricey to contract service providers, but this is also coinciding with the population of our new structure that we have now developed after the restructuring. So hence other provincial heads could not attend today because we are prioritizing those interviews. They are busy with the interviews. That structure will be populated, and we will review where we are possibly in the next 2 weeks or so, and continue to just assess how the other projects are unfolding. But they are just not standing still. They are being investigated, of course, with the need for further resourcing. We get it from the panel of service provider as prudent as we can, so that we don't want to be spending lots of money on the service providers, but we then recruit permanent heads to improve on the resourcing of SIU.
Thank you.
Thank you. Thank you.
Honorable Yusuf, you've got 2.5 minutes. Just one thing, can the technicians just have a look at the sound? Some members are battling to hear. If they can just sort out our sound. Honorable Yusuf, over to you.
Thank you, Chair. And really, I think that we should all be grateful to Advocate Matibi for doing the best he can and trying to make things work given the resources. But it seems clear that the resources are inadequate. And despite our raising this issue a number of times over the past year and a half, I think, that there's no relief for the SIU on that. Advocate Matibi, I just wish to, you're doing a great job, and please don't feel that there's criticism here, but the concern is that when you enter into these agreements and recover money, the people who have been involved in the misdemeanor, what action is taken against them to prevent them from ever doing business with the state again, or perhaps facing a criminal charge for their action? What I'm saying is that recovery of the money is very important, and I commend you for that. But is that the end of the journey for these evil people? Or is there the process unfolding to have them criminally convicted if that's the nature of the offense, and certainly to be blacklisted, to never be able to do business with the state again?
All right, thank you very much, Honorable Babu Mtibi, and then we will move on to the next member.
Okay.
Yeah,
well, thank you, Honorable.
Once we've gone through the first round of questions, members will then come back again if there are any other issues. So that's not, I'm just wanting us to be as patient as possible with today. Right, Babu Mtibi, over to you.
Thank you, Honorable Chair. Honorable Liz, the agreements that we enter into, such as acknowledgement of debt, acknowledgement of liability, which ensures payment, I think in the presentation we did underwrite that and say it does not absolve the service providers or employees that were involved in those irregular processes. Firstly, from further criminal prosecution, And yes, indeed, today, up to now, we have not referred the blacklisting aspect. That is the aspect that happens subsequently, but we do take into account that so that we act on time, we need to speed up even the blacklisting aspect. So what happens is we would then refer to the accounting officer or accounting authority our view that this service provider made themselves guilty of irregularities, and this is the nature of it. We are of the view that the state institution concerned has to process a blacklisting process because it's their responsibility. It's an administrative law process where now they enter into a process to give the service provider the opportunity to present their case and so on and so forth, and then ultimately a decision is made to blacklist. We've noted that, and I'm sure my colleagues are also listening. At the next project review, we will have to fast track those kind of blacklisting processes. So, and they also they are not absolved from ensuring that there's criminal prosecution where evidence is found. The acknowledgement of debt only dispenses with the civil process because, and that's why we enter into an engagement with the state institution to make sure that it is the accurate amount that has been suffered by the state institution and is due and payable. So once that is done, we dispense with the unnecessary litigation costs, but the criminal prosecution and other outcomes, indeed, thank you, such as blacklisting, will have to be executed. Thank you.
All right, Honorable Van Menen, your 5 minutes starts now.
Thank you very much, Chair. And I really want to echo what the Honourable Lee said. Advocate Matibi, thank you very much to you and your unit. I think that if fraud and financial irregularities were an Olympic sport, South Africa at this particular point would certainly be looking at a podium position. So we really do appreciate the work that you're busy doing. However, I've got just some clarity questions really, I suppose. One is the issue of the Ledler structural development. By my calculations, although you acted very fast and moved very quickly, there's still at least 14 million unaccounted for. But what I actually want to know is, given what was already happening and there was an investigation in place that people knew about, are actions specifically being taken against the people responsible who proceeded to make the irregular transfer of 38 million? And is that actually being tracked, or was that part of the court case which has now been concluded? Because it is very worrying that although people know what is in fact in the pipeline, those payments were still made. And it certainly, from what we can see in the report, indicates a deliberate intention to disperse monies irregularly or fraudulently. The second issue was the legislative changes that you were talking about with regards to people of prominent local influence. How far are the moves to, in fact, make those legislative changes? Because it certainly seems that it is something that is pertinent. And there is a lot of public discourse about that. And then also, apropos of what you were discussing in the previous responses, we last week dealt with the Department of Public Works and the Beitbridge fence, the two companies there. And there was an enormous reluctance from both the head of the DG and also the minister to clarify what was actually happening with those companies. And we had excuses about the fact that there were numerous other contracts with those companies, that there was a great deal of money at play, but they hadn't behaved irregularly in any other respect. And it certainly seems the department is seemingly intent on frustrating your attempts to, in fact, blacklist companies like this. So what are your powers or authorities vis-a-vis departments that are trying to evade this kind of responsibility? Thank you.
All right, Honorable Van Menen, thank you very much. Honorable Babu Mtibi, over to you.
Thank you, Honorable Van Menen. We appreciate the words of encouragement. On the later structural matter, we did say the contract was for 139. We have stopped the payment of 100 million. 39 million was paid, and 24 million has been forfeited to the state. So correct, there's that 14 million gap. And I was in the process of reaching out to our legal team because it can only be from the judgment that they've drawn the rationale of why this gap. So I'd like our legal team to look at that, and possibly at the end of the session we can provide an explanation, Honorable Van Minen. With regard to the Bait Bridge fence, our view is that on the contract, and we remain steadfast on that view, that the contracts were irregular, and we are of the view that the Special Tribunal has got the jurisdiction to hear this matter. So, and that's why I said earlier on that the issue around blacklisting would really follow on the conclusion of the process. But where the processes have been concluded, we need to be able to do the blacklisting process. In this regard, the contracts have not been set aside yet. Of course, we've made the finding and we are in court at the moment. So once the judgment is handed down and we are in a position to get the order where it's been set aside, we should then by law be able to then say, you had an irregular contract, it's been set aside. By the way, we are also dealing with a legal principle here that says a contract is valid until set aside by a court of law or a tribunal in this regard. So once it's set aside, we will then be in a position to say, you had an irregular contract here, this was your infraction, this is how, and then we then complete a documentation that we send to the department and say, we are of the view that this company has to be blacklisted. With regards to other contracts, Honorable Van Minen, I don't want to mislead the committee. I'm not aware that they've got other contracts. We can check that, and if need be, open up the investigation to reach out to those contracts as well.
Just on that point, HOU, the Mahua Construction and I think Trans-Caledon was reported to us that they've got 19 projects that they're doing with the Department of Public Works to the value of 400 million rand. I think that's what Honorable Van Minen is referring to. But we will sort those details and then we'll get them to you. But it's
thank you.
19 contracts or projects, and their value is 400 million. So right, you may proceed.
Yeah. No, thank you, Honorable Chair and Honorable Van Minen. We'll appreciate that information, and then we can then act on it appropriately. Thank you.
All right, Honorable Van Minen, you may proceed.
Thank you very much. I do appreciate those responses. Just the one point we still need to cover, which is the progress on the legislative changes relating to the prominent influential persons. I think that hasn't yet been answered.
Oh, okay. So apologies for that. As I indicated that the FIC, on reading our report, proactively reached out to us. We were in a position where we were going to reach out to them to start this process, go through the legislation. Then our legal team, and in fact, we are busy arranging a session between us and them, myself and the director of FIC and the legal teams, where we will then start discussing this point and look at, these inefficiencies that we have pointed out and what are the safeguards that we're looking for, look at the current legislation and then make the recommendation. And we'll probably have to also engage the National Treasury in terms of that, and we will update the committee of where we are with that, so that then it can be tracked within the legislative process. Thank you.
Right, Honorable Van Minen.
Sorry, excuse me, Honorable Chair. I hope in the later construction there were questions whether actions have been taken. I can assure the committee, Honorable Van Minen, that actions have been taken. Some of those actions have been included in the referrals against the CFO, against the head of the SCM, against the head of the department. I would also include that against the MEC. As we speak, those actions have been taken. We are monitoring the disciplinary processes. The criminal investigation is underway relating to the corruption that we want to go deep into. Hawks, NPA, we are supporting that investigation. Thanks.
Right, Honorable Van Minen.
Thank you very much. I'm satisfied for now. I might ask something again later.
Okay. Thank you very much. All right. Honorable Mente, your 5 minutes starts now.
Thank you, Chair. Thank you very much, Chair. My first question to Advocate Mothibi, and thank you very much for the report and the work you have done so far. There's a concern I'm having where the collusion of inflating prices is amongst the department and the primary service provider. We know the chain of these service providers. Most of the time, there's a tendency within our government, like you have indicated in some of the instances where there are points, BE points given to people who do not qualify. And you'd find that indeed those people do not meet the criteria to have had business with the state in terms of their registration. They don't meet the requirement. However, what they normally do, they source the material which is needed by the state from people who indeed qualify to provide such services. And those people will quote the proper prices in line with the regulations of Treasury. Now, with the primary service provider who's contracted with the state, has inflated prices, colluded with the officials of the state, having to not be paid now, correctly so. But then when you come across such instances where the subcontractors are meeting the requirements, they have provided the services properly, what then becomes an intervention, and what the process becomes thereof from your side to ensure that the people who did not sign up for this corruption are not affected, and what then becomes a process between yourself and the department after freezing the accounts of the primary service providers and then freezing the pensions of officials. That's my first question, Chair.
All right, thanks. Let's get a response. Honorable Mothibi.
Thank you, Honorable Chair. Honorable Mente, thank you for that question. Indeed, we do come across instances of collusion and inflation of prices, as we have indicated in the Gauteng space, that there has been, inflation of prices to the region of up to about 400%. And that, of course, when the investigation reveals that, it obviously raises questions, and we then are required to act accordingly. Now, we have indeed found, especially if I use the leisure construction example, that the money, or we contracted, or not we, the Department of Health contracted with the leisure But remember, this matter unfolded from Royal Baka, and when the allegations raised, Royal Baka pulled out, supposedly, and they brought in Leisure. Leisure was then the one that contracted with the Department of Health, right? So, as we found these irregularities, and it also appears in the judgment that was handed over on the 4th, is that we did find that Leisure was actually a proxy of Royal Baka. And that's the point that we've made out, that in fact Royal Baka did actually not withdraw from the whole picture. And then in the judgment, or when we traced the monies, that were paid to Leisure, we found that they were distributed to other companies. Now, that's probably where the issue of subcontracting come in and so on. But when we do the investigation, our focus is on the entity that has contracted with the state institution. In this regard, when we set aside the contract, we set aside the contract of, say, the Department of Health and Leisure. Now, if there are indications that there were subcontracting, and that the subcontractors would ordinarily not be affected, and that they were affected simply because, you know, of the corruption and the collusion that happened at the top, it would probably be for them, there would be legal remedies that are available to them, so that they could institute suit or civil suit against this entity that had contracted irregularly with the department. Remember, if the evidence possibly reveals that you know, there were subcontracting, I cannot recall that in this instance there was active evidence that came up that this was the main contract and these were the subcontractors, you know. But in cases, assuming that we find evidence that says the main contractor and these were the subcontractors, the team would probably dive deep into what did he charge, where did he source the material, you know, at what price, and how were the others prejudiced in the process. So the point I'm making, Honorable Mente, is if there were others who were prejudiced in the process because of this main contractor, their legal avenue would be against this legal contractor. So as far as we are concerned, or with the state institutions, our legal interaction ends with the main contractor. And if the contract is set aside, that's where legal relationship ends. If I make a further example, if we have contracted with this main contractor, assuming there are no irregularities in this case, in this example, and the contractor fails to deliver, right? If he fails to deliver because of the subcontractor who did not come to the party on time, for example. So the state cannot now, this main contractor cannot say, I didn't deliver because of the subcontract. So the state cannot now go down and institute an action against the subcontract because the legal arrangement is between the two. So that is why I say, if in the example you have given, there are people who did not commit wrongs, but it's almost a vicarious liability, you know? They find themselves, you know, in this quagmire because of the person that they are associated with. So their legal recourse would be to the person that, you know, sort of caused this whole quagmire. So I'm not sure if I'm coming out clear, but I'm dealing with it based on the legal principles and the legal relationship.
All right, no, that's fine. Honorable Mente, you may proceed. You've got 2.5 minutes.
Thank you. Okay, Ngozi Advocate It's clearer, even though I would like to have asked more questions, but then let's leave it there for now. Now, you mentioned in terms of your limitations, the destruction of evidence, and some unavailability of officials for them to prolong the process, maybe because they were trying to check if they can resign before you get to them and all those things. Now, from my point of view, that's trying to defeat the ends of justice.
Yes.
I just want to get a confirmation from you that part of what you have sent to NPA, the officials, because they are not given by names and in terms of charges linked to them in terms of the report. Them trying to defeat the ends of justice, is it part of that? Number two, are the departments in terms of the DCs referred to departments, is that also part of the charges? Because trying to do that in order for them to explore ways of getting out of this mess they've created when they see that they have been caught, was that made clear? And if we can, from your side, get the list of these particular officials that tried to do that, because there's always an intention behind every action. And their intention was clear, to either resign or try to get through the good books of whoever is in charge of the minister or mayor or whoever, so that they can be sent to another department or somewhere else. If we can get that list, and if the charges are clear in terms of their names, let me add in so that I don't have to come back again.
As you wrap up.
Okay. I think Honorable List asked these questions. Where people are making admission of debt, it means they are admitting that they are guilty. Then there's the issue of them being blacklisted. What comfort can you give us, especially with your interactions with the National Treasury regulations, where people admit guilt, and therefore it means they must be removed from the system altogether? What comfort can you give us in terms of your side? Because you always do your work thoroughly, but when it then comes to Treasury, like you have cited a very good example, that you are now sitting with FIC to try and make recommendations when it comes to people linked to prominent people. But what then becomes a relationship between yourself and Treasury regulations in terms of blacklisting these people? What is clear? What is a clear document that we can use, which you are using to blacklist, to make sure that these people don't come back again, as well as the officials involved? Thank you.
All right. You will come back in the second one, Honorable Mente, no problem. HOU?
Thank you, Honorable Chair. Thank you, Honorable Mente. The destruction of evidence, that we have found, of course, as we mentioned it in the limitations, but more often that is mitigated by the fact that we are able to even trace through the computers that we seize and the servers that we seize. The teams have really devised other investigative methods to ensure that the evidence is collected. But there are, yes, those instances where evidence gets distracted. Can I just give this example? And I'm just making really a reference to it. Recently, I think last week, we saw a building ban in in one of the Gauteng warehouses, and it was in the media, and we are busy investigating as part of the infrastructure investigations. That building is part of our investigations. Right? So those are the perhaps that's a worse example, but you find other examples where evidence is destroyed without using fire and so on. But in this instance, you may find that we can try to reconstruct the evidence, but you find that if they've used the fire and the store is bent down, we will then be unable to reconstruct the evidence. But if then the documentation has been, say, destroyed by fire or any other means, we expect that they would have been backed up by the department, and the backup should then be electronically. And in the instances where there has not been backup, unfortunately, that's where the evidence gets missing. And in that regard, we then have to make just the systemic recommendations. But of course, in your follow-up question around, we have to ensure that we then pursue the criminal case. In the warehouse, in example that I've given now, last week, a case has been opened up. The Hawks are investigating whether it's arson and so on. So we do, yes, find instances where people deliberately, and do acts that are meant to defeat the ends of justice, right? This unavailability of officials, in many instances, our investigating teams would approach the witnesses and enter into them an arrangement based on their willingness, to participate and cooperate with the investigation. Right? But in some instances, I have stated it clearly to our investigators that the SIU powers are in the legislation for a reason. So we shouldn't be at all times going, in quotes, cap in hand and ask and request a witness, that has been identified as critical to the investigation, or a certain document that's critical, we request. So with immediate effect, we use the SIU powers to subpoena the witness, or we subpoena the document, and then the question of unavailability gets dealt with. Then you see that they start cooperating, because if they don't now respond to the subpoena, then there's other legal consequences. So in the case where we find specifically that the witness has really been playing truant and making themselves unavailable, and with the intention of defeating the ends of justice, up to now, and then I can check that point, Honorable Mente, I do not recall that we have specifically, and my colleagues are in the room, that there is a referral on there defeating the ends of justice. We can verify that, but of course, that is taken into account in cases where the teams identify that there's been a deliberate attempt to defeat the ends of justice. That should form part of the referrals to NPA, and also be included in the charges for disciplinary processes. I've made a note on that. When we come back to you with the list, and thank you for that point. I should have mentioned it when I started, that we have not mentioned the names simply because of the legal risk that we have mentioned before. But yes, we can provide that list in committee to the committee, so that you have sight of that, and we'll request the team to put that list together. In fact, I've already requested them, because I anticipated that that question may come up. So we will collect that list and then submit it to the committee. In terms of the acknowledgement of debts, yes, indeed, those are, as you call them, admission of guilt in a way. And that should then, the point that I was making around the bait breach fence, where we are waiting for the court to declare the contracts irregular, and then we can follow up with the process of blacklisting. In the case of acknowledgement of debt, this, as you correctly say, is an admission of guilt or an admission of wrongdoing. Then we should be in a position to immediately refer our recommendation for the department or the municipality to institute a process to declare, to blacklist. That is another process that is envisaged in the administrative law processes. So we should be in a position to refer immediately once the acknowledgement of debt is entered into. And then we, although the responsibility is with the state institution to do that, we can then also copy in the National Treasury immediately so that they are also cited in that process. We will immediately put that that process into action, particularly around the ones where they've acknowledged the debt. Thank you.
All right, thank you very much, HOU. Mam Tolashe, you are next. Mam Tolashe has got a special privilege. She won't turn her camera on because of the technicalities with network, so that she's audible. So that's why she won't be showing a camera. Mam Tolashe, over to you.
Thank you very much, Honorable Chairperson. Good morning, Chairperson, colleagues, and the delegation led by Advocate Mativi. Honorable Chairperson.
The 159 million contract.
Advocate
24.
Advocate Mtivi, please mute.
Apologies, Chair.
Okay, sure. Mam Tolashe, you may proceed.
Thank you very much, Honorable Chairperson. Honorable Chairperson, in welcoming this report that we have just been receiving from Advocate Mtivi and the team, we quite appreciate the stride that they have made since the last briefing. They are quite huge. As a result, we appreciate them. Thank you very much. The first thing that
just 1 second, Advocate, please mute. You are still audible this side. Right,
thank you, Chair. The first question that I would want to ask from Honorable Advocate Mtivi is the issue that was raised by my colleague earlier on, the work versus the resources that they are supposed to be using. Can we get a concrete report to say, as they're embarking on this kind of most important work for the country, can we be assured that they do have resources at their disposal so that nothing will make them not being able to move forward even faster than they are doing? Secondly, Chair, I heard from Advocate Mtivi talking about the officials that sometimes don't cooperate, especially those that are in the SCM. I'm just checking whether they are able to monitor that those officials are being suspended by their heads or whoever they are reporting to make sure that we are sending a message that suggests that if you are involved in corruption, we must be investigated until you are proven guilty or not guilty. But you can't be at work at the same time, because my fear there, you'll be doing the same thing and now you'll be more vigorous than you were before, as you now know that you might have to, we are going to exit. 3, Chair, the Advocate Mtivi spoke about the fact that in the KZN area, they've requested the Department of Social Development to stop paying the service provider. Is there a tool where they can make sure that, in fact, that does happen? Because the experience that we're having as we're sitting in this committee, we get to realize that some of the things that were raised and there was a recommendation to stop them, there are other ways that are being created to get involved into it without all of us knowing. Is there a way for them to make sure that that instruction is being honored? The second last one, Chair. Advocate Mutibo is saying the issue of the corruption in the South African Defence Force, the military police, they are investigating. Just want to know, do they have the same powers with yourselves, that is the military police? Are they on the same page where we are? Wherein after investigation, people must be taken to court and everything according to the book must happen. So that I'm fearing here, Chair, a situation where we'll have parallel processes that might end up maybe with the advocate Mtibe and his team. I really would want to hear that more. Chair, I know I spoke about I'm worried about a situation where the team investigated and they did not find any wrongdoing. Can we check there whether the people who are complaining are majority of time genuine or are sometimes mischievous? I'll tell you why. There are sometimes tensions in departments and so on. My fear is that the SIU is being used to fight people's battles. Is there a way where we won't be able to, we might not have to put our resources that are limited to a situation where we're not going to get the necessary end result? How can they avoid that? I know sometimes it's difficult, but there should be a way to say, where the last one, Chair, the business are being banned, the office and so on. What then happens when you discover that, in fact, there's no backup? For me, because I think whoever who is the head of department in that regard should be liable, because you can't have information that you need in the next 10 years or so being seated somewhere and in that place only and nowhere else. I think the BFMA might not agree with that, but I want to hear more, because I guess this now is going to be a trend. Those are my questions from the to the Advocate Mtibe and his team. Thank you very much, Honorable Chairperson.
Thank you very much. Right on time, Mam Tolashe. Right. Thank you very much. Babu Mtib, if we can get responses.
Honorable Chair, up front, let me apologize for the sound that apologize for that. I was talking to our legal counsel to calculate the difference that Honorable Van Minen asked about on the ledger structural matter. So, Dr. Wells, when you're ready, please, we'll need to update the committee on that. Thank you, Honorable Tolashe. The resourcing that we are using, we can assure the committee that we will be able to progress this investigation in the timeline which we have indicated. And by the way, I need to just put it on record that for the matters that are being investigated now, that are on our books, we have said we aim to conclude all these matters in the next 6 months. A tight timeline, yes, but we have looked at the resources. We've looked at how is it that the teams can be supported. So we can assure the committee that the investigation will be progressed. At the moment, I did say that we are populating and filling the structure that we have, but we are also using the panel of service provider that we have. We want to use it less and less because it's costing a high amount of money. We want to use it less and less. But of course, we can't stop it 100% because there are those other experts that we know ordinarily would not employ, that like the engineers, quantity surveyors, and so on. So, but in the main, the general skills that we need, we should have them in-house. And as we populate the structure, we should be able to have that. And this includes on the other projects other than COVID-19, but on those ones, we have sought to keep them going based on the prioritized outcomes. Of course, we can improve on those to ensure that they are fully resourced. The officials not cooperating, as I indicated, that as the investigators move in, for example, if we start investigating, say, at the Gauteng Department of Health, the investigators will move in having identified who can assist the investigation, and they will then approach the person and say, we need your time, we need to take a statement from you, and so on. More often, they start off like that and not use the peremptory legal provisions. But when we realize that this person is not cooperating, we then immediately use our SIU powers to subpoena, and then more often we find that they do ultimately cooperate, of course, because now they have been forced legally to cooperate. So it's an observation we've made over time that if you go in and depend on their willingness to cooperate, you don't always get them cooperating until we force them by law, to cooperate with the investigation. So in case of suspending those officials, indeed, if we identify that this is the key person, for example, in the SCM section, that's going to hamper the investigation if they do not cooperate or they remain present at the office. We do recommend to the head of the institution to suspend the employee in question. And more often we've found that the heads of the department, they do listen to our case, they understand, and they do take that action. The KZN area stopping of payment, as we reported, our KZN team has reported formally that the department has actually informed them officially that they have stopped payment. So the question now would be that we need to monitor that payment is not made contrary to their undertaking. So we may then have to put in measures in place to ultimately, when we probably complete that focus aspect of the investigation, to go back to the department to verify and probably include financial auditors so that we can audit the payments of the department and we satisfy ourselves that there has not been any payments. Sorry. I will take that up with the KZN team, assuming that the provincial head is also in the meeting. But we will, in so many ways, take it up and then so that we are able to report on the next occasion we appear, or we can give that report immediately in between the meetings. The SANDF, I was informed, in fact, our Chief National Investigating Officer, Mr. Lekheto, I'm sure he's in the meeting, he can confirm that. When this matter was looked at, they interacted with the SANDF military police, because my question to them was, we must also ensure that Hawks is involved, because we're dealing with organized crime here. This syndicate is an organized crime. So, but I was informed that they do have similar powers like the police, that they can investigate, similar like Hawks and SAPS can investigate. So we have said we will stay close to the investigation and satisfy ourselves that it reaches the appropriate outcome. Where the team investigated and did not find wrongdoing. Oh, yes, Honorable Tolashe, I would like to really agree with you that as part of our assessment of these allegations, we also ensure that there's no what we call fishing expedition, where the allegations are palpably unsubstantiated, even at the first submission of those. So we've got a focused case management team that receives the allegation, and they assess them, and they test these allegations against what SIU needs to investigate. So more often, once we have done that, we find that there's a legal base to investigate. But yes, indeed, even when we've done that, we do find that ultimately, and this no wrongdoing. We come to this conclusion after we have gone through the documentation, through the process, testing it against the allegation, and we come to a conclusion that there was no wrongdoing in the process. So the issue around those who are likely to use SIU for personal interests, we often determine it at the first stage where they really cannot substantiate these allegations when we test them against our scope and our mandate. And there's been various cases which we have closed because they do not pass the test of being within the SIU mandate. In many instances, you find that they are community-related complaints, and then we would then refer them to the public protector. In some instances, it's matters related to regulatory processes. Then we would then refer them to specific regulators. So yes, there is that risk that other people could really be out on a fishing expedition, but we have checks and balances in the SIU where we test these allegations. Now, in the instance where we find that there's no backup, it has really never happened in so many ways, because the documents that we normally would need, they would also be on the server, and we in many instances, when we get the laptops and get the cell phones, and our team is able to image them and trace the documents appropriately. But assuming that we find that there was no backing and we can't find those documents anywhere, and I'm on record to my teams that more often you'll find that a team would say, we couldn't find the documents, now we are closing the investigation. So the instruction I've given is that you don't end there. You have to find out if there has been poor record keeping. We have to find out who was responsible for that record keeping, right? And there is an obligation on every state institution to safeguard the records, and the appropriate people have to be identified so that action can be taken, including the head of the department, because the obligation rests from the CEO down, from the head of the department down, to ensure that there's adequate backing in the organization. Thank you, Chair.
Okay, thank you very much, advocates. Let me just get the next honorable member. Right, Honorable Hatebe, your 5 minutes starts now.
No, thank you so much, Honorable Chairperson, and take this opportunity to also follow suit and welcome the presentation by the SIU. Most of my questions, Chair, have been covered, but I will focus on the few that have not been covered. The limitations, Chair. Starting with the limitation that says local politicians' involvement in the administration of the municipalities. I'd like to get a sense and understanding, are these local politicians part of the municipality or they are outsiders? If they are part of the municipality, the Local Municipal Systems Act is very clear in terms of councillors being prohibited from interfering with administration. And if they are outsiders, this is tantamount to state capture, or should I say municipal capture. I would like to ask a question. If you'll be in a position to give us a sense and understanding, which are these municipalities that have been captured and what has been done? Have you brought this matter to the attention of the municipal council to act decisively against the state capture, if indeed these local politicians are outsiders? But if they are insiders, also the responsibility lies with the municipal council to act decisively. So my first question for now will be to get clarity on that matter, Chair. Thank you.
All right, just to get a response to that.
Right. No, thank you, Honorable Hadebe. A typical example, it's the JB Max, I think, in the western, in the northwest. We have found that an office bearer, other than an employee, and those could be in the category of politicians, that there has been, and I'm just using this as an example, there's been an evidence that shows that a donation was given out, contrary to the municipal rules and so on. So as you can see there, that we have actually referred it to the MEC consent, and the MEC consent has undertaken that he will follow up. It's an executive or an administrative referral, like we covered it in our report. So that's just one example. If there's other example, well, the other example of political interview, there's others in other provinces which when we have finalized those processes, we can appraise the committee in terms of which provinces, which departments we are referring to here. But JB Max, I can mention because it's in the report. I can mention the Gauteng department because we've already made a referral. MEC, we have made that referral and action has been taken. So it is in that context that this this limitation we've pointed it out in terms of politicians interfering with the state administration process. Honorable Hadebe, I can check further with the teams if there are further examples, and then I can submit them in writing together when we submit the list that was requested by Honorable Mente. For now, I'll give that example in JB Max, where we have already actioned and we have raised it with the MEC so that action can be taken. I will go further and check if there are other examples. If they are at a stage where they've been finalized, we can report them.
All right,
no, thanks.
Proceed.
Yes, no, the second limitation, Chair, it's in relation to SIU members that were threatened and intimidated by both officials and service provider. Now, Chair, you'll agree with me, this is a very serious matter and an arrogance of the highest order. In fact, it is anarchy. For those that think they can loot the state coffers in return, they have an audacity to threaten and intimidate SIU members. from doing their job. What steps have you taken in this regard? Have you dealt with these threats harshly? Because they need to be dealt with as soon as yesterday. If not, soon enough, it will be us who are going to be threatened for doing our work. And I'd like you to be specific and tell us if you are at the position to indicate which areas or these instances have occurred, so that we know what we're dealing with. We don't want to sugarcoat the truth and call a spade a digging spoon. Thank you.
Yeah.
All right, let's get
thank you.
I think Advocate Honorable Ladabe's question is very important because it runs parallel to the issues that the AG has raised previously. The intimidation of auditors when they're doing their work. So if this is now fast becoming a culture across these institutions that are supposed to be working in those spaces, we need to deal with that. And Honorable Ladabe, I can assure you, anybody who tries to intimidate us, they run the risk of not taking themselves very seriously. So they dare not do that. But I think what you're raising is important in light of what the AG has previously picked up. So if you can substantively deal with that, we'll show you.
Okay. At the moment, an example I can give is that, and we assist as we speak with that process. In the Free State area, we've had one of our investigators being intimidated and threatened. We have had to get the SAPS involved. They did a quick threat analysis because we also act based on the informed threat analysis that has been done by SAPS. We've documented it, and we have now put measures in place by SIU, because the SAPS will say, this is the threat assessment, this is what you need to do. And as SIU, we then have to take steps to ensure that our members are protected. We have gone ahead and did what we have to do based on the assessment, and the member is now under protection. So that's just one example. From time to time, we just get our investigators indicating that to go in a certain area, they would need further protection. So we do act as and when based on the merits of the case and the assessment that we get from the SAPS. And in some instances, when we go and conduct search and seizure, right? Because our investigators are not armed, right? So what we do is that because search and seizure by its very nature is intrusive, and you find pushbacks and to an extent attacks. In the Western Cape, for example, when we went to do a search and seizure in one of the municipalities, the team was constantly on the phone with me and saying, we can see people out here, you can see that they are really on the guard and so on. But of course, when we did that, I immediately, when we went for a search and seizure, I immediately called the provincial commissioner, Matakata, who was very helpful to provide the team that would go with our team to go and do the search and seizure. So that's the kind of collaboration that we have to ensure that we deal with some of these threatening instances. So we continue to monitor the space, and this Bloemfontein example I've made, honorable members, comes at high cost. The security measures that we had to put in there are really quite costly, but we are enjoined. It's incumbent on SIU and us as a responsible investigating agency to do that and make sure that our investigators are protected. But I think for now it suffices to say we've taken measures, and we can demonstrate that in cases where we have picked up that there are threats, and we have acted and ensure that our employees are protected. Thanks.
No, just 1 second, Honorable Hadebe, before you proceed. I've been advised that load shedding will commence at 1300 hours this afternoon. And so I hope that members will check their local schedule, so that members will just advise me if they will be affected at that time, so that we can bring them in early to raise their issues. But it seems as if there will be load shedding from this afternoon at 1300 hours until 6 a.m. tomorrow morning. So we are just in constant crisis mode. So members, please do advise if you will be constrained, so that we can bring you forward and you can finalize all the issues that you want to raise before we proceed. All right, Honorable Hadebe, you can proceed with, sure.
Yeah, no, thanks, Chair. Just to make a follow-up on this very limited original documents kept by state institution, have you gone as far as checking up on what are the provisions of the procurement policies of these state institutions in relation to record keeping? Because I know there should be a certain duration where documents and records for any contract should be kept safe in an eventuality where there are appeals and stuff like that. So have you done that? Because that's, to me, if there are insufficient information, it's tantamount to maladministration and non-compliance. And any state institution that is found to have committed such should be taken to task and be brought to book. We cannot allow instances where we'll tolerate maladministration. But second to that, Chair, we once engaged with the interministerial task team that was launched on the 6th of August 2020, and its main purpose and function was to collect and gather information in relation to all COVID-19 procurement. So haven't you resorted to asking them to assist and furnish you with information where you find instances of limited information for the execution of your work? Because one anticipate that you need to work in collaboration with all the structures that are put in place to deal with this issue of COVID-19 allegation and corruption thereof. So the question would be, have you taken this matter forward, and have you identified the culprits? Is the interministerial task team assisting in terms of availing information where you're falling short of getting such an information? Thank you. I'm sure Chair, I still have time to ask questions.
You have exceeded your time. You will come back in round 2. We are on time. All right.
Thanks,
Honorable Hadebe, I think you should go to the WhatsApp group here committee. There's an interesting comment about you there. You will enjoy it. Over to you. We are on the group because we are also trying to mitigate these shortcomings which are always coming our way. So it's for that reason.
Thank you. Thank you, Honorable Chair and Honorable members. Honorable Hadebe, yes, in terms of documents missing and not provided to SIU, and that is the instruction I was referring to, that the team should really look beyond any official that's saying the documents are not available. It should not end there, because there are legal requirements. There is a specific legislation that requires state institutions to keep records. So we look at that legislation in terms of the time frame within which the records should have been kept. And more often, when the documents are no longer being used, they are stored offsite. Most of the state institutions do really lead us. The documents are stored and then they provide them. But in cases where the documents are not provided at all, contrary to this legislation, which requires state institutions to keep records, say for 5 years or whatever period, then we have to make sure that we find who was responsible for safekeeping. If that person cannot be identified, and of course the accountability goes up to the accounting officer or accounting authority, because there would have been a failure of the organization to keep the records as required by law. The IMC Yes, we've been in contact with the work of the IMC. In fact, it's been very helpful because remember, they collated all the contracts of COVID-19, and the repository of those contracts is at National Treasury. Our teams have reached out to the National Treasury and got the list of those contracts. But that list only the contracts. It doesn't go further and gives the supporting documents and so on, which are the documents which should be kept by the state institution. So we have received the cooperation and the assistance from the IMC. Thank you.
Okay, thank you much, Honorable TB. Right. Babu Somya, your 5 minutes will start now, and then colleagues, you will indicate again if there's follow-ups that you want to do. We are still good for time. We've got about 45 minutes. So, yeah, so Babu Somya, your 5 minutes starts now.
Well, thank you very much. Thanks to the Advocate Mutiba and his team. The report has covered quite a lot for us to indicate as to how far have we gone on civil matters that relate to COVID-19 expenditure. So that I don't lose the context. The context would have been that in the first instance, the president has formed what was called or is called a fusion center, and through that fusion center, all state organs that are looking into matters of law enforcement meet together and look into these matters, and therefore SIU would form part of such a unit, and therefore depending on the information which crept through that process. Some of the information would come from the Auditor General, which earlier on, towards the end of last year, when we met the entire team which operates through the Fusion Center, we were told of about 80,000 matters that have gone through that center, which require some investigation by those who are involved in the unit. Thanks to SIU for its own operational initiative in as far as these matters that relate to civil issues and the success rate thereof. And my question would then go into as to how far have we gone in terms of the scale to balance up on all those kind of reported matters at the time. I've heard that the Advocates Focus team is looking into about 13 billion rand expenditure, which is a bit questionable, which itself has been reduced through their own investigations as they found others not necessarily liable in terms of the criminality that has been alleged in those contracts. The success rate in as far as such units are concerned, because this element we're talking about now is only on the civil litigation matters, which itself is limited to about 13 billion rand over plus 30 billion rand expenditure on the matter that relate to PPEs. The second area is the area that relates to a comparative that the SIU runs through from national to its own provinces. Have you ever had some kind of an assessment in looking into equally the success or failure of handling the matters at the provincial level and national level. You have made reference earlier on that certain matters are handled nationally, other matters are handled provincially. Is there a scale that could demonstrate some form of a qualitative gains in as far as that comparative, in as far as functionality of the SIU, both at the national and the provincial level, which is my second point. If you would allow, Chair, I would go to the third point, because I don't want to lose the context of all these things, because they are coming about because in the first instance the president has had issuance of those directives for matters to be investigated, and therefore the results of such a kind of issuance measures which would demonstrate how far the SIU has gone. The matter might not need the SIU, it might well need us, but where are the others in the scale of dealing with these other matters that relate to criminality along the actual operation in as far as expenditure is concerned and finalization of such instances on the basis of good governance in as far as the state is concerned. I'll just stop there for now, Chair. Thank you very much.
All right, thank you, Babu Soma. We have somewhat exceeded your time, but we'll go to round 2 of the questions and we'll have another list, right? The head of unit may respond to that. And then
thank you.
Comment afterwards.
Thank you, Honorable Chair and Honorable members. Honorable Chair, I've just been informed that there's a possibility of load shedding in our area at 13 hours, but we do have a generator. It takes about we count up to 10 seconds, and then it kicks back. But then there becomes a bit of a delay before the systems reboot. So I thought, let me just announce that and record it. Honorable Somyo, thank you for the questions. The Fusion Center, indeed, we are part of that. And as I indicated to the Honorable committee earlier, that we did have the ACTT meeting yesterday. And amongst others, we do receive reports of the Fusion Center. And of course, we were quite clear with them that in our report, in our SIU report, we do not cover the Fusion Center report. So that report should then be submitted separately of the Fusion Center. But most of the matters that we report on would have been, also been reported to the Fusion Center. So Honorable Chair, perhaps the committee could consider where the Fusion Center could submit its own report to the committee, and then it can see how it's progressing. And yes, indeed, even yesterday, the Auditor General came to the ACTT and submitted their second report, which they issued, and it's for the Fusion Center now to take that into account and see how do we take